So, Mr. Balui, you made how many copies?
Enough copies just for
Yeah, but in other words, how many copies did you get? Is it 1 copy or 2 or 3?
We got all the copies back.
No, you're not listening.
Yes, sir.
This witness, how many copies? Let's say, how many pages of the order I said he must give us the information on? How many did he make?
2.
When did you copy second? How many copies did you make?
There was only one.
1 copy.
One copy, madam. And
Okay.
he made just enough for council.
Right. So every council has got that order, and every client has read it. Mr. Mkomazeli, the client read it also.
Not.
This witness says he read it. Sir, are you saying you saw even number 1 reading it? And number 2?
He was sitting together with him, but I'm not sure if
And
he
number
was
3?
All
All 5 of
Number
them.
1 went to the group, my lord, and they looked at it together.
All 5 of them.
Correct.
Can you give all 5 of them copies? Copies so that I just read what the law requires. Mr. Baloi, can you give each and every accused that order which was supposed to be made for this court, which has now been publicized?
We will make them copies.
Now give them now. I've got to see them getting it.
Well, we only made enough for council. We'll have to make extra copies now.
Councillors have got all copies. Mr. Ngomezulu, do you have a copy of that order?
This is the copy. My
Do you have a
colleague is-
copy?
No, I'm about to receive a copy now.
Mr. Mnisi, do you have a copy?
We thought we needed to take them back, madam, but now they have been returned back.
No, you have to get copies, all of you.
Yes, it is the court.
Mr. Numalo and Ms. Misholo, you all have copies.
Yes, I've just received it, Madam. Thank you.
Yes, my lord, I've also just received it. Thank you.
Yeah, I had originally ruled that that order must be expunged. But after having consulted authorities, in terms of our law, there's what we call a posterior ruling, a statement. And Black's Law Dictionary, the 10th edition, defines it as such. A formal statement endorsed on the trial record. That's what I'm doing. I'm endorsing this order, which I thought it's going to be confidential, on the trial record. Giving an accurate account of the proceedings at the trial, which I hope I've done. A record of what occurred at Nisi Prius after the issue had been joined. The issue was joined on the basis that when this witness, Sergeant Mokhanene,
Yes, my lord.
was being cross-examined, he repeatedly said he's unable to divulge the information regarding the investigations of the cases which you say accused number 1 or 2 or the others they're involved in, because he would be revealing confidential information. Am I quoting you correctly?
Ke nnete gore kgoro e re lena le rile go na le dilo tse e leng gore ga le kgone go di bolela ka lebaka la gore go na le ba bangwe ba ba latofatšwa ba e leng gore ba gona go melato e nngwe gape le tlabe le ntšha dilo tse e leng gore ke diphiri ka sewe sebaka. It is correctly quoted, my lord.
Yeah, because this court hopes to be fair. There was a dispute as to whether this witness is actually, his testimony is actually the truth or not. And at that stage, this court is not involved in joining whether this witness is being truthful or not, because it's at the moment giving evidence. This court decided, in the interest of justice, that if it is actually correct that these cold cases he alludes to, including the Nongoma case regarding the murder, the court should make a a request in the form of an order that this witness should itemize and categorize those cases in which he says they are cold and they are at the moment not yet finalized, because it was put to him that, for instance, that Nongoma case was finalized, and he said, no, it's not finalized. And by that exigency, this court expected and hoped that this court will get the information which it will share with the accused counsels, that in fact, indeed, such cases are still being investigated. Is that not your evidence, sir?
ga se botlhatse ba lena se kgoro e fetsa go se bolela ka dijalo gore melato eo e santse e nyakišišiwa. It is correct, my lord.
Consequently, that's why I made that order. And I was of the view that that order is made for the information of this court. And in terms of this posterior principle in our law, I was going to call all the counsels into my chambers and show them the confidential information which was divulged after being extracted by this witness from the various dockets. Because I believe that counsels are officers of this court before they are defenders of their accused. That's a sacrosanct principle of our law. You are officers of this court before you are defenders of the accused, because when you are admitted as counsels of this court, you take an oath to uphold the law practices of this court. So one would have expected that even if counsel informs their clients about the fact that in fact it is correct that there is proof that some of the cases which the gentleman is giving evidence on, saying they are cold but they have been resuscitated, in fact it is correct that those cases are being attended to. And I believe protocol dictates that not everything which this court divulges by intruding into the Official Secrets Act. And if counsels understand that exigence, you don't have to tell your client about the fact that they say one of the murderers there is Mokgoatlheng, because you are enjoined to the privity of the information which has been divulged in this court, because this court has made an order that even if it is in terms of the Official Secrets Act that this witness was saying he can't divulge that information, but this court, using its inherent jurisdiction and Section 173 of the Constitution, as Mr. Minister likes saying, you can make use of that information under certain conditions. Okay. So consequently, if anybody wants to use that information, which has been so irregularly being divulged, you are at liberty to do so. And this principle starts from the 15th century. So that the man say, I did judge lay is a long church. With the verdict of the jury in the 15th and 16th centuries, the proceedings at Nice Prius closed, and the case was sent back to the court at Westminster, from which it was issued for judgment, after a statement of the holding of the trial and the verdict that had been added to the record, as I'm doing. This statement, from the fact that it has begun with the Latin word posterior, or afterwards, was known as the posterior and was in fact drafted by the party in whose favor the verdict had gone. Whence the phrase posterior to the plaintiff or the defendant, which is found in the old reports. You can see in this regard Geoffrey Ratcliffe and Geoffrey Cross, Legal Systems, England. It's a 6th edition textbook written by Bentley and Hand. It's the 6th edition if you want to read about this any further, 1977. Okay.